Mr. Anderson, in this matter, you're before the court charged with civil contempt of court as a result of your failure to pay child support and or related expenses.
Mr. Anderson is before the court on docket 2016-1806DS. This is an adjourned bench warrant hearing. He did resolve his bench warrant through front of the court, so there's no bond to address today. Mr. Anderson has a current monthly obligation of $98, with an additional $49 toward the arrears and $3.50 in service and processing fees, for a total monthly obligation of $150.50. His last voluntary payment was October 5th of 2022. That was $55.04 through an income withholding. Mr. Anderson failed to appear August 17th of 2022 for a bench warrant hearing before your honor. This is the fourth bench warrant hearing. He's had 0 prior contempt findings. His total shortfall for 4 months of compliance is $602. The arrears through the end of May are $730.06.
Okay, thank you.
You're welcome.
Okay, Mr. Stackrider, do you dispute or contest any of the statements made by Ms. Brown?
Yes, Ms. Brown, can you hear me?
Yes, I can.
All right, on the sheet, again, you've added a $250 bond, is that correct?
That's not a bond. That was a payment to resolve the warrant through front of the court.
All right, and is that put towards his child support obligation?
It does.
All right, so why does that raise his compliance from $602, added $250 to $852, and then re-subtracted $250? Why does
Because
that
it's
lower the $602 by $250?
so it's included. I'm sorry, Mr. Sackright, are you done?
Yes, sorry.
Okay, no, it's no problem. So in measuring the 4 months of compliance, which is $602, I included the lump sum of $250, and I included that he paid that $250. It's not a voluntary payment. It was to resolve his warrant. So it brought it back down to the $602. Just so there wouldn't be any confusion about him paying $250 through front of the court, but his last voluntary payment shows as October 5th of 2022.
Okay. All right. Has he ever been offered the LEAP program?
Mr. Anderson has not been offered leave from the case notes. And just so you are aware, and the court is aware, this generally is not my case. But no, during our last conversation, Mr. Anderson, let me look at the notes, Mr. Sackright. I want to be accurate.
Okay, hold on. Mr. Anderson, are you still there?
He's muted.
Yes.
Okay. Just want to make sure you had it, the phone or whatever it was outside showing us the sky. So
My phone is close to my ear because the phone is kind of low.
okay. Okay, that's fine.
I'm ready. So no, Mr. Anderson was not offered the LEAP program. When I spoke to him on June 7th, where he requested the attorney, he stated to me at that time he is not going to pay child support because the minor child is out of state. And so in him stating that he's choosing to not pay child support, I did not offer LEAP.
All right, so you spoke with him?
On June 7th.
All right, but this is not your case?
Normally, no. I did cover it on the 7th, and I'm covering it again today.
All right, I have no further questions.
Okay. Any proofs, Mr. Sackrider?
Yeah, I'd call Mr. Anderson.
Okay, go ahead.
All right, Mr. Anderson, can you hear me and unmute?
Yeah.
All right, you heard the testimony of Ms. Brown. Did you disagree with anything that she said?
No, I don't. Everything she said was completely accurate.
All right. How many children do you have with Nadia Briggs?
Just one.
All right. And do you receive parenting time with that child?
No.
All right. And were you receiving parenting time before?
Yeah, I had to go through my mom to get parenting time, or my little brother to get parenting time. She dropped her off to them instead of calling me or letting me get her at any time.
Okay. Miss Brown said that you were refusing to pay child support. Is that accurate?
Yes, I was trying to get in front of the judge to get someone else involved in the situation because she was avoiding giving me my daughter, and I can show messages of her saying she wanted to leave my daughter with me, but at the last moment decided to take my daughter out of state without telling me and didn't let me talk to my daughter for months. My mom had to beg her to bring her up here for the summertime, and now she's up here in my care for the rest of the summer.
All right. What is your child's name with Nadia?
Riley Nicole Briggs.
Riley. All right. Riley is in your care now?
Yes.
All right. Are you willing to file a motion for custody in this case if necessary?
Yes, I just filled out the paperwork today and can turn it in to you guys tomorrow.
All right. Says here your last payment on child support was October 5th of 2022 in the amount of $55.04 through income withholding. Where were you working in October?
October, I was working at graphic packaging.
All right. Have you been working since then?
No, I recently got a job for 2 weeks, working at JBS, and then my car broke down. The
All right,
engine blown on my car.
When did you start at JBS?
May 1st, lasted till I want to say about May 10th is when my car broke down. Well, the engine exploded on my car.
All right. Were you able to, why didn't you make any payments on your child support from the income from JBS?
Because the income on my checks were only $500, and I tried to get the car fixed, and the car is currently getting fixed.
All right. Where are you currently working?
I just recently scored a gig working on houses.
All right. And when did you start that?
Today.
Okay. How much do you earn there?
Right now I'm just on an apprenticeship for anywhere from 10 to 15 an hour. I'm not sure yet.
Okay. Are you going to be able to make payments on your child support obligation in the future?
Yes.
All right. Are you currently taking, what's your highest level of education completed?
Current highest level of education completed was high school diploma, but I'm enrolled in the fall classes for KVCC.
Okay, so you're enrolled at KVCC in the fall?
Yes.
All right. All right. Anything else that you would like to tell the court?
No, sir.
All right. Nothing further, Your Honor.
Okay, thank you. Mr. Anderson, you, sorry, so you say started working today on working on houses, is that correct?
Yes.
Okay.
Well, I started apprenticeship today working on houses.
I'm sorry, I didn't hear you. What was that?
An apprenticeship working on houses today.
Okay.
It's not.
And you'll make $10 to $15 per hour, correct?
Yeah, until I'm here.
Okay. You understand on the issue of support that is not, again, it's not mutually dependent upon, again, the issue as it relates to parenting time, that you have a right to, if you're not getting your parenting time, you have a right to file a motion to have the other party held in contempt of court. You understand that, sir?
Yes.
Okay. Just want to let you know that, so that if, again, you're not receiving that, that you do know that you have an avenue available, but that doesn't impact your support obligation as long as that support order is in place.
Okay.
Okay, anything else that you'd like me to be aware of, sir? Yeah, we're not hearing you, Mr. Anderson,
No.
so. Yeah, we're just getting words here and there. We're not able to hear any sentences or anything like that. So say it again if you have something, sir. You're muted now. You have to
No,
unmute.
sir, I don't.
It shows that you're, okay.
No, sir, I don't.
Okay, thank you. Anything else, Mr. Sackrader?
No, nothing further, Your Honor.
Okay. Well, the court does note, I've heard the testimony in this case that, again, that Mr. Anderson had worked for approximately 2 weeks at JBS, period of time in early May, that he said he made about $500 per week doing that. He obviously had money that were available. He utilized that to, he claims, to fix a car that had apparently was damaged or whatever, that again needed repairs, etc. That he said he has a job now that he just acquired, that he'd be working on houses. Today was in fact his first day, where he'd be making $10 to $15 per hour. He does have high school education, and he's enrolled at KVCC as well in this matter. Court will note that based upon this, that he has had the ability to pay his support obligation. His obligation is only $150.50 per month, and he has not done that, notwithstanding the fact that he's had income available to him. So he's had available resources in which to pay. The court has not heard any testimony shows that he does not have the ability to acquire and maintain employment. As a result, the court will find that he has voluntarily failed or refused to comply with the orders, notwithstanding having the ability to do so. With that, anything before sentencing, Mr. Sackrader?
Yes, Your Honor. My client testified that he is caring for the child with Miss Briggs in this case. That he did. He's at his job today. He does have the ability to start paying on any child support obligation in the future, and that he is going to file a motion for a change in custody. It's for those reasons that we would ask the court to not impose any jail sentence in this matter. Thank you.
Okay. Well, Mr. Anderson, what I'm going to do is I could sentence you up to 45 days in jail. I'm not going to do that. What the court is going to do is I am going to sentence you to 10 days in jail with credit for 0 time served. I'm going to allow you to purge yourself of contempt by paying the sum of $300, and you'll pay that no later than June 30, 2023 at 4:00 p.m. If you fail to pay the purge amount, then you'll have to report to the Calhoun County Jail to serve the balance of your sentence. You understand that, sir?
Yes.
Okay. So hopefully you'll get that paid prior to that date, and then you won't have to go to jail. So court will end this matter at 12:54 p.m. You're free to go. Have a good day.